Welcome back, brothers and sisters. I am Braden. This is Langley Outdoors Academy, the place where we not only talk about what's going on in the gun world, but also how we're going to fix it together. And the content today is some of my favorite type of content. We get to dive into the minutia of things that don't necessarily go on during the week and show you the power of what the impact is we're having. This is going to be something you guys are going to love because a stalwart New York liberal judge is saying, guys, the Bruen decision is going to destroy us all, and I'm kind of siding with it. This is amazing. Like I said, everything will be linked. Of course, make sure you hit that like button, subscribe to the channel, and turn the notification bell on. And if you guys want to support the channel directly right before Christmas coming up, we have our new merch line. It is linked right down there. It's called Libertas, and it has everything you'll need to get ready to rock and pursue your beliefs in what you wear in the lifestyle brand that we have put forward. And thank you for checking that out. All right, guys, we've got to dive into this, and I am so here for it. My brothers and sisters, when I read titles like this, I can't wait to get them to you. Stalwart Liberal on New York's top court says she would strike down gun law. Well, that's a title and a headline you don't see every day. Let's dive in further because this happened amongst all the insanity that was going on this week with all the breaking news that we had across the board. Check it. New York State Court of Appeals Judge Ginny Rivera, one of the top court's two most liberal jurists, says she would strike down a state law that makes it easier to convict people who possess loaded firearms without a permit following the U.S. Supreme Court's landmark Second Amendment decision last year, the Bruen decision. What took you so long? Now, being completely fair, because I try to keep it as fair as possible, even if you're a liberal, kudos for coming to the right decision because the Supreme Court set the standard. It may conflict with your own personal viewpoints, but you're a judge. You are not an advocate. So, legitimately, kudos for getting there. Now, the rest of them haven't, but it's important because it speaks to something broader that's happening across our nation and the judiciary. Let's keep going because, like I said, this is mind-boggling to me. In a dissenting opinion from one of the several gun cases decided last Tuesday, Rivera said it was time to invalidate the law at issue, which says the mere possession of an unlicensed firearm implies an intent to use that firearm illegally. So possession is no longer assigned to intent. That's a really big deal because the entire impetus behind the leftist gun control desires and all of their pushes is, well, if you have a gun and it's a loaded gun, then you have negative intent. Not necessarily. You're kind of assigning intent based off of your own liberal bias. That's the whole point. This has happened in a lot of different jurisdictions as well. But this is in New York. Any of the other laws starting to come up into your mind about what is happening in New York? Let's keep going. This implication enshrined in law is used to prosecute certain gun crimes, some of which have so-called intent requirement. Remember, all these requirements that they're doing. So if you have a gun, then you have an intent to do something. If you want to have a gun carry license, then you have to prove you're worthy of it. You have to prove that you have some sort of determined need, and we'll let you know. This is a New York staple, and it's being questioned like this by a liberal judge? Okay, let's continue. Given the Bruen majority's holding, the statutory presumption is unconstitutional on its face as it requires the jury to assume a defendant intends an unlawful use of a weapon merely because they possess the weapon in public. Yeah, that would be unconstitutional, and in my opinion, morally wrong because you're assigning intent based off your biases. But anyway, let's continue. Though she was the sole judge to call explicitly for the demise of the key gun law on constitutional grounds, Rivera's dissent may be a harbinger for things to come as courts across the country reevaluate the legality of all manner of gun restrictions in the wake of Bruen. Bruen is striking hard and fast at the gun control heart. If you recall, we covered something last week about Giffords.org saying 450 gun laws are on the books on the chopping block. This is kind of what they're talking about. They're putting up a real big, strong game on the front, on their Twitter accounts, on their social media posts. But behind the scenes, this is the type of thing that is happening. Make no mistake, they are posturing from a position of weakness, and this is what's really going on. That's why we cover these things. That's why we are here talking about it on a Saturday. Now, last piece. So while this intent law certainly makes it easier to prosecute gun crimes, it's rarely the linchpin that would cause a case to fall apart, and this last piece is the key. Nevertheless, Rivera cautioned in her opinion that the wider effects of the Bruen decision may yet be felt soon as other restrictions are challenged in court, with immeasurable effects on the safety of our neighborhoods. So you can see that her underlying personal preference here is still clearly intact. but she's acknowledging the fact that Bruen will not allow certain things that have been a mainstay on the gun-controlling left for decades. They're about to have a reevaluation because they can't do what they've deemed as they can. And this is a big deal, and it's not just New York, but it is a harbinger. Hey, look, I said it. For things to come. Everything will be linked in the description box below, and I can't wait to hear what you guys think. Check out those shirts, and I will see you on the next one. I'm Braden. See you later.